Now we're going to turn to Florida, where a hearing was set to get underway in the penalty phase for the Parkland school shooter this morning. But in a sudden shift, the court canceled today. And as you remember, the 23-year-old has already pleaded guilty to 17 counts of first-degree murder for murdering students and educators at Marjory Stoneman Douglas High School back in 2018. His penalty phase is to determine whether he should be sentenced to life in prison or to death. We saw the state rest their case before the extended break, and the defense will begin theirs as soon as they return. But today's hearing was set to center around the defendant's mental health and whether his brain scans would be admissible as evidence in the trial as a mitigator. And we have Court TV legal correspondent Julia Janae, who knows all about it. She's outside that courthouse in Florida with the latest. Julia, I know you showed up early this morning, ready to go, and then everything was canceled. What happened?
A sudden change today, Chanley. Everyone was there, including these parties, the judge, members of the media who were going to be watching it. We didn't expect the jury, of course, to be there, but we got word before anything started at 9 o'clock that they were canceling the Daubert hearing, and then we got some more insight into why this happened. This is coming from the state attorney's office. They said that they would pass along to us that the defense team notified the prosecutors and that they, also the judge, and that they've agreed not to present those issues that were addressed in the Daubert motion that was filed by prosecutors. More details will be provided at the status hearing that the judge has scheduled for tomorrow afternoon. That's going to be around 1:30. We don't know if there are other issues the court is going to take up, but when it comes to Daubert, when it comes to the expert witnesses that the defense was planning to call, that the state objected to on certain issues, it sounds like from this statement the defense is pulling back, that they are no longer going to be pushing for the use of the analysis that was somewhat controversial. It's controversial when it comes to the criminal justice system. QEEG, quantitative EEG, it's a type or procedure of reading EEGs and understanding what those brain waves mean, but not definitive or reliable enough, according to the prosecution. So they were going to challenge it in front of this judge, but the defense no longer planning to put that information in front of this jury, Chanley.
Julia, and I know you've done a lot of research. You're a lawyer as well. Of course, for those watching, explain what is a Daubert hearing? They're not attacking maybe the conclusions of the expert, but how that expert reached those conclusions. And I keep seeing brain scans, the QEEG, and it's like, make it plain and simple for us. You're the best to do that, JJ.
Right, if I can. If I can. You almost have to be a scientist. And, you know, that's the reason for a Daubert hearing. The purpose is to allow the court to be the gatekeeper, to make sure that if there's methodology, if there's scientific processes that are not supported by testing, not supported by reliable methods of doing things, then the judge is going to be the one to look at it, hear the testimony, hear the arguments before it goes to a jury to determine if we even can put things in front of the jury. Now, of course, there are things that are age-old. DNA, fingerprints. You're not usually going to have that type of methodology in front of the judge. But when we're talking about brain scans, when we're talking about QEEG, which is something that emerged over the last decade, it's still something that hasn't become well settled and accepted scientific methodology inside of a courtroom, though it is something that is used to detect early signs of Alzheimer's and MS. So definitely something in the medical field that is cutting edge, but whether or not it can determine whether a defendant has a certain brain abnormality is something that required in this case because of the challenge by the state to go through the judge. And to your point, it's more about the methodology. Some of these experts used that data and compared it to other homicide defendants, other murderers, and made the connections or said that Nicholas Cruz's tests were consistent with what they saw in those, but the state arguing that that simply is not something that is easy enough for them to verify if that kind of methodology is legitimate enough for this jury to even weigh in on.
Interesting. And you said, you know, settled and accepted form of science. How often, I guess, has this sort of brain mapping or this science been used? Has it even been used in the Florida court before? Would there have even been enough for the judge to say, yes, it was settled and accepted?
It has been attempted many times here in Florida, but for the most part, it is not allowed in front of the jury. There is one case we were able to find, the Grady Nelson case. Back in 2010, a judge did allow quantitative EEP, QEEP procedural process information in front of the jury, and that jury found that defendant, they essentially determined that he should get the life sentence instead of the death penalty. So it was a penalty phase similar to what we're looking at now, and those brain scans were reportedly very important to at least some of those jurors' decision because it showed that this person had a predisposition to violence and to being impulsive. So something similar that we likely would have seen with Nicholas Cruz. His attorneys were going to suggest that through these expert witnesses that he did suffer from fetal prenatal alcohol exposure that you see there. That's some of the defense mental mitigation that they were going to get out through that expert testimony. Also, they are going to show that he was exposed to nicotine while his mother was pregnant with him, that he has cognitive and intellectual deficiencies, and that he has a capacity, or his capacity to appreciate the criminality of his conduct is impaired. We will be seeing still experts on the stand. This does not limit the defense in what they are going to be presenting in general, but when you talk about those specific types of software, NeuroQuant, and the QEEG type analysis, that is not going to be coming in front of this jury.
Interesting, just fascinating, and great job breaking all of that down. I understand now, thanks to JJ. But now that this hearing, again, has been canceled, you read that prosecutor's statement that the defense not presenting this. What is next? I mean, there's a status hearing tomorrow. What's, I guess, what we're going to see this week and next week when the defense case picks up?
You know, it was slated for the Daubert hearing all week, so it's possible that they could not have anything else this week. But there is something that the defense and the state are still hashing out, and that has to do with the brother of Nicholas Cruz, Zachary Cruz. There's some questions the state has been pushing to get from him that have to do with his financial situation, who he's living with now. Zachary Cruz may be a witness in the defense case to talk about his brother and the challenges of their upbringing. So that may be something they deal with now that they have more time, because the Daubert hearing has been canceled. But ultimately, we are looking forward to August 22nd. That's when the defense is going to begin their case, and likely is going to begin with opening statements because they did not present one at the beginning of this case when it started last month.
That's right. Julia Janae with all the latest there in Florida. Thank you so much, Julia. I'm going to bring in my guest, former special agent in charge for the Georgia Bureau of Investigation, still with me, Trebor Randall, and criminal defense attorney and entertainment attorney Daryl Cohen. All right, Trebor, I'm going to start with you. Did it surprise you that the defense said, oh, we're not going to do this anymore, and canceled the Daubert hearing?
Not at all.
Why not?
Again, this is one of those cases where, you know, we're at the last phase. Any last-ditch efforts, you know, that they're hoping to change the outcome. I just can't imagine much. I know that, you know, everybody has their difference in opinion about whether or not this, you know, deserves life in prison versus the death penalty, but I don't think them canceling the hearings did not surprise me.
Yeah, and it sounds, Daryl, like the defense has plenty of other mitigating factors or evidence they're going to present. Maybe they felt like they didn't really need to go through the brain scans, or it would have made a difference maybe to this jury.
I think the defense has to go through DBI, Daryl's Bureau of Investigation. And what that really means is they're looking desperately for anything, 1, 2, or as many items as they can to prevent their client from receiving the death penalty. Why they withdrew this today, I don't know. We may know later. But whatever they have, they need to give it to that jury if it appears that it'll be helpful to their client. Because in my view, he's going to get the death penalty, and then if they could give it to him 2 or 3 or 17 times, they would.
Right, especially after that emotional prosecution case in chief here for phase 2. Now, Trebor, would we hear from Nicholas Cruz and his sentencing or his mitigation?
I think that, and I know, I know Daryl would agree, I think that that would definitely be a bad move. I can't imagine his team allowing him to do that. But ultimately, we've seen stranger things, such as in the honor killings. The last person I expected to hear from was the father, but yet, you know, here we are watching him. So I don't think that he will. It would be quite interesting. For me as an investigator, I would love to hear what he has to say.
Absolutely, and we heard from him when the judge, you know, he pled guilty, excuse me, to the guilt phase, and his presentation wasn't the best. So yeah, I'm kind of with you. I don't know about whether or not his defense team would want him to say anything, but we'll see.